Alright, Subchapter F, Underground Natural Gas Storage Conservation, Section 91.17.1, short title of the subchapter may be cited with the Underground Natural Gas Storage Conservation Act 1977. Alright, Section 91.172, Declaration Policy, Underground Storage of the Natural Gas Program for the Conservation of Natural Gas for the permanent build and preserve of the orderly withdrawal within the period of the peak demand, making more readily available the natural gas resource for the residential, commercial, and industrial customers of the states, provide with a better round market of the various gas fields for the promote public interest and welfare of the state acts added in 1979. 91.17.3 definition in this chapter: the person means any natural gas partnership or other combination of natural person, corporation, group of corporation, trust, the government entity, gas utility, maybe the gas utility defined in Section 101.003 Utilities Code or Subchapter 8, Chapter 122 Utilities Code. Natural gas, meaning the gas material composed predominantly following hydrocarbon, the mixture thereof, the methane, ethane, with the propane, with the butane, normal isobutane, in either of the original manufactured state, with the gas has processed separate into one or more of its component parts after its withdrawal from the earth and natural gas. The natural gas means natural gas which has not previously been withdrawn from the earth, and natural gas which has been withdrawn from the storage facility process, re-injected into the storage facility. Storage facility means any subsurface stratum of the formation used to be used for the underground storage of the natural gas, also for the surface rights for the appurtenances necessary to the operation of facility for the underground natural gas storer. Means a gas utility, B, wholly owned subsidiary of the gas utility, C, with the parent corporation of the gas utility, D, wholly owned subsidiary of the parent corporation, which is wholly owned subsidiary gas utility, but with a non-utility storer included in this category. B, C, and D, or B, C, or D must operate with the storage facility pursuant to the contract with its affiliated gas utility. Provides that all withdrawals of the natural gas from the storage facility must be delivered to the affiliated gas utility. Substantial to believe that means at least 75% of the estimated volume of the recoverable natural gas reservoir originally in play with the gas barium sand formation stratum has been withdrawn in the sand formation stratum. Interested person means any person who enters appearance at the commission hearing required Section 91.174 of this code. Commission means the Railroad Commission of Texas, added in 1977, amended in 1999. Section 91.174 finding with the commissions: any store with a desiring to exercise the right with the eminent domain for the acquisition of the storage facility shall have the condition precedent to filing of the position with the appropriate court with the commission of the order. Findings: the underground formation of stratum solvent to be acquired, classified by the commission a gas reservoir suitable for the underground storage of the natural gas. That storage natural gas is necessary for the gas utility provided with adequate service to the public in the public interest. The use of the formation stratum as a storage facility will cause no injury to the surface of the underground water resource. Of the formation stratum does not contain the natural gas produced with the providing quantities unless the recoverable volume of the gas originally in play for the substantial is depleted, unless the formation stratum of the greater value with the ultimate with the consumable public and storage facility to ensure adequate supply of the natural gas for the conservation of natural gas. Then the production of natural gas, which remains the extent of the horizontal limits of the reservoir, except with the penetrated display with the injected gas, and the no portion of the formation stratum strata to be acquired with the dim, but being utilized for the injection, storage, withdrawal of gas or others. Designated storage does not prevent any store for the instituting additional proceedings in the event, and later determined underground reservoir shall be extended with the event escape the displacement withdrawal by other injected gases. Add Acts 1979, Section 91.17.5, Commission Jurisdiction. Commission have the jurisdiction to supervise the construction operation of all storage facility formed pursuant to the subchapter with the adding and defining of the required in Section 91.17.4 of this code. The Commission shall include any other approval of the requirement for the storage filer report each month, including each prior month prior to the time the storage facility is in operation, which the Commission showing with the volume of the gas injected the storage withdrawal of the escape. Section 91.17.6 of the withdrawal of the natural gas of the store may withdraw of the storage injected the stored gas over the market of demand with a dictate, however, any of the time the store withdrawals from the storage of the facility equal to the volume of the gas injected. First store of the storage shall not withdraw additional gas from the storage facility without first obtaining specific authority from the Commission, added Acts 1979. Section 91.17, seventh storage operation must be bona fide. A, that the store must initiate the injection operate for the gas storage within 12 months after the condemnation order of the court becomes filed, and the storage operation must continue with a reasonable diligence after this time. Should the monthly reports of the Commission indicate that the bona fide underground gas storage operations are not being conducted, the Commission may, at its own motion or on a motion of the interest of purpose, should schedule a public hearing, give the store the opportunity to call for the Commission approval of project should not be withdrawn. If the Commission finds the storage project that is not being conducted with a bona fide manner, they shall issue the order with the withdrawing approval of the storage facility, and all property involved, mineral and surface condemned by the store shall revert to those owned property at the time of the condemnation of the or successors. Acts 1979. 91-17-8, relocation of facilities. In the event that the acquisition, operation, store facilities required for the exercise of the power of the eminent domain, required for the relocation, alteration, railroad, electrical, telegraph, telephone, pipelines of the facility. Expense for the relocation, alteration should be borne by the store. For the expense of the relocation, meaning the actual cost incurred for the providing a capable replacement line or facility that's not salvage value from the sale of the other disposition of old facility as Acts 1979. Section 91-17-9, appropriation store facility limitations. After the order of the Commission is issued, approve of the store facility of the store of the may condemn without further act as the right of the condemn any subsurface and formation of underground storage, natural gas, condemn all of the mineral rights of the necessary and reasonable and necessary for the operation store facility, subject to the limitation of the subchapter. The store may be condemned on any other interest of the property with required include with the interest and surface of the estate with the sand, straight information reasonable and necessary for the operation store facility, provided that no part reservoir subject to condemnation when the use of the store is acquired with the option of lease conveyance with the other negotiated means with at least 62 and 2/3% of the ownership. Mineral include may working interest of 62 and 2/3% of ownership of the royal interest of the computed with relation to the area of the overlying part of the reservoir which is found with the Commission to be expected with the penetrate with by displacement and injected space. 2. No dwelling with the barn store over the other building is subject to the condemnation, right combination with is without prejudice of the justice of the owners of the beholder of the other rights of the interest of the land with the drill with the storage facility under the right for the terms and condition of the Commission and prescribed for the purpose of protecting storage facility against the pollution of the escape of the natural gas without prejudice of the right of its own separation holder with the other right interest of the land to hold the other uses so long as the users do not interfere with the operation of the storage facility added Acts 1979. Section 91-180, Institute of the Condemnation Proceedings, of finding with the Commission with the underground storage is in the public interest of the finding involved in all person who with the property store with the has right to condemn. After defined with the Commission with the store with has the right to condemn all of the underground storage area with the answer for the required with the use of the enjoyment of the storage facility. The storage shall initiate with the eminent domain proceeding with the court having the jurisdiction in the area which portion of the land is situated with the petition shall set forth for the purpose of which the property is sought to be acquired and the description of the transient formation of the land under which is in alleged of the beginning. Name of the owner shown by the deed records of the county, the description of all of the other property rights to be appropriated with the connection within the storage facility, including all parts of the service necessary for any facility, incidental operation store facility. The petition shall state with the facts showing that the store with the obtained finding of the Commission required by the section 91-17-4 of the code of the store with the good faith of the unable to acquire with the rights to be appropriated of the store has acquired with the prior to filling with the petition by any other means with the condemnation of at least 62 and 2/3 of the percent of the ownership of the minerals, including work interest of the 62 and 2/3% of the royalty interest, copyright, property rights, and storage facility required for the purpose of describe the surface area of the overlying the storage facility. The store seeks to acquire the names of the owners of those rights interests when the more than one tract land is involved with any of the tracts enjoined in one proceeding without prejudice of the right of the store of the institute of additional proceeding provided with the failure to make service to the defendant does not affect the right of the store proceed against any and all other defendants on whom the service has been made. 91-181, except for the right of the eminent domain, all proceed with the connection with the condemnation and acquisition of store facility shall be according to the article 3264 through 3271 revised civil statute of the 1925 is amended to the extent of the conflict between the articles and the subchapter provision of subchapter prevail added Acts 1979. Section 91-18-2, ownership of the stored gas, all natural gas straight with the condemned with the non-native gas for the which for the subsequent shall inject with the store facility, personal property, property injected with the sign with an event with the gas utility, gas subject to the right of the ownership of the service of the land with any of the mineral royalty owners, the interest of the owner of the which for the store facility lie with over any person with the other injector produce the take of the reduced possession, either by means of the law of the capture, otherwise waive the otherwise interfere with any of the control over the store facility upon failure with the neglect with the refusal of the person to comply with the section action. Store have the right to compel compliance by the injunction or the appropriate relief of the application to the court over the competent jurisdiction. Acts 1979. Section 91-183. Rights of the purchase of the natural of the gas of the event of the remaining of the receipt of the natural of the gas of the storage facility with the dedicated of the purchase of the pressure of the store of the ability unable to agree with the equatable settlement of the rights of the respect of the remaining natural gas within the period of time will prevent interference with the operation of the storage of the facility. The store of the purchase must apply with the commission for the adjunction concerning the main reservoir of the natural gas. Upon application for the commission shall the direct with the settlement of the remaining reservoir of the natural gas equatable to all of the parties which does not interfere with the public benefits of the arising with the operation of the store facility. In addition, with any other disposition equatable with the all parties of the commission may find with the quantity of the remaining recovered in natural gas for the election, allocation, future production, reasonable production, schedule with the other delivery with the purchase and store with the amount of the daily gas over the commission finds we have been taken the purchase during the term of the purchase agreement added Act 1979. Section 91-18 for abandonment. When the store is permanently abandoned with the storage facility with the shore shall file with the commission with the notice of abandonment shall file with the instrument of the deed with the records appropriate with the county with the storing, stating that the storage has ceased and that all the property in both of the mineral and surface condemned by the store has reverted to those of the owned property within the time of the condemnation of their heirs, successor, and assigns. Storage shall be the storage shall also have the deed records appropriate with the county with the or counties, the list of the owners of the mineral royalty with the surface of the owner with the various interests of the reverted, together with the affidavit that the store has complied with the list of the current examination title records that have the list of the true and correct to the best knowledge of the affiant. Acts 1979. Alright, subchapter G, underground natural storage. Definition, chapter for the underground hydrocarbons facility with the storage, meaning with the subsurface terrain with the geological formation for the underground storage hydrocarbons, include the surface rise for the appurtenancy for the necessary for the operation of the facility. Hydrocarbons being with the oil, gas, the product with the oil, with the gas, as determined by the defined section 85.001 of this code. Waste for the means of surface, the subsurface waste for the defined section 85.046 of this code. Hydrocarbons included, not limited to the physical, economical waste allowed for the hydrocarbons create operation made with the abandonment of the underground hydrocarbon storage system. Commission means the Railroad Commission of Texas. 91-202 for the policy statement for the purpose of the chapter for the prevent waste oil for the gas for the product oil for the gas protect for the ground surface oil for the trade with the unreasonable degradation to protect for the public health for the welfare physical property creation operation maintenance for the abandonment of the underground hydrocarbon storage facilities. Acts 1981, 91-203, Authority Rule of the Commission shall supervise mine with the construction operation maintenance with the closed storage facility with the Commission shall the man adopt with the reasonable rules or issue reasonable order with the implement with the policy with the subchapter of the man shall with the minimum standard with the regulating with the creation of the operation maintenance with the abandonment of the underground hydrocarbon storage facility. Rules stand with the Commission and include but not limited to the requirement of the monitoring of the record, keeping the reporting with the drilling creation of the facility, selecting the site of the facility, and for the proper closure of the facility on the abandonment. Acts 1981. 91-204, permits of the Commission by rule may require the person created for the operator to maintain a ban with the hydrocarbon store facility to obtain with the permit from the Commission. The permit issued for the Commission may contain with the provision conditions necessary to implement the policy with the subject of the Commission may adopt reasonable rule for the amendment of the revocation, transfer, of the suspension of the permit. The person desiring an operating permit to amend the permit must supply application containing information required by the Commission. Acts 1981. Section 91-205, authority to enter property of members of the employee of the Commission and enter for the public property of the properly reasonable time with respect to the investigative condition relating to the creation of the operation maintenance with abandonment of the underground hydrocarbon storage facility of the member and employees may enter for the private property have the management reside without notifying with the management of their presence for the shall observe the safety, internal security, fire protection rule of the establishment being inspected added in 1981. Section 91-206 authority to examine the records. Member of the employee of the Commission may examine the copy of the during with the regular business hour with the pertaining with the creating of the operation maintenance for the abandonment of the underground hydrocarbon storage facility. Acts 1981. Section 91-207 the notice for the compliance on receipt of the notice for the Commission of the person creating with the operating maintaining with the abandoning of the underground hydrocarbon storage facility. Storage facility has violated the subchapter determined the condition provision permit issue with the subchapter of the operator with the pipeline other carrier with the connected with the facility shall with the disconnect with the facility shall remain with the disconnected from the facility until the notice of the compliance has been received from the Commission, and one received with the notice of the Commission of violation subchapter of the rule of the Commission is issued under the subchapter of the term of the condition or provision of permit issued with the subchapter of the owner of the operator with the underground hydrocarbon storage facility shall discontinue any removal of the hydrocarbon in the facility with addition. Hydrocarbon in the facility may not begin with a removal of the hydrocarbon in the facility with the beginning with a new addition. Hydrocarbon to the facility until the notice of compliance has been received from the Commission added to Acts 1981. 1981. Subchapter H, underground storage facility for the natural gas. Its definition of the chapter, interstate with gas pipelines made with the assignment of the United States Department of Transportation, Title 49 U.S. Standard Code 60101, attends with its subsequent members or succeeding laws. Natural gas means the gaseous material for the primary methane and is either originally or manufactured natural gas only for the storage of the means for the storage of the natural gas between the surface of the earth and formation rather than reservoir. For storage facility has meaning assigned with the Section 9117 Acts 1977, amended Acts 2013, Section 91-252, Commission jurisdiction over the natural gas underground storage subsurface equipment facility over the use of the natural gas on store with the subchapter does not apply to storage facility that is part of the interstate with gas line pipeline facility defined in the United States Department of Transportation, subject to federal minimum standards adopted with the Title 49 Section 60101. As subsequent amendment of the Succeeding Laws, Acts 1977, amendments in 2013, Section 91-253, Commission enforcement. In addition, the other opportunities specifically granted with the Commission over the subchapter of the Commission for the chapter of the rule adapted for the under the permit issue with the subchapter provided in 91-207. B, Section 91-003 does not apply with the subchapter. Acts added in 1997. 91-254 with inspection, examination, credential for the Commission may inspect with the store facility with complying with the safety standard with the practice for the record, keeping added up to the Section 91-252, 257, and 258. Conducting inspection under this section, and a commissioner of the designated with the Commission employed with the agent may enter for the property storage facility is located with a reasonable time in a reasonable manner. 1. Facilities are related to buildings or for the equipment of the records required for the maintained and stored facility under 91-258 for the commissioner of the employed with the agent and the enter for the premises of the storage having personnel over the premise of the person over the facility unless the proper credentials are first presented with the person in the facility who is in charge of the property, adds Acts 1997. Section 91-255, safety standard practice for the Commission rule shall adopt the safety standard practice for the natural gas under the ground store facility with the standard of the practice required for the installation of the periodic testing safety device. 2. Establish emergency notification procedure for the operator facility and event with a release for the hazard for the substance posed the substantial risk to the public. Establish fire prevention and response procedures. 4. Require training of the employee with the storage facility on the safety operation of the storage facility. They establish other safety standards of the practice for the reasonable, necessary underground nature of the gas and the safety of the construction operation made with the storage facility. The Commission may adopt the different standard of the practice for the different type of the storage facilities made with the distinguish among with the natural gas underground salt with the dome with the caverns depleted with the reservoir embedded salt formation. The Commission may grant for the examination standard of the practice for the top of the under section for the permit the amended permit issue for the storage facility exemption will not constitute the unreasonable danger for the public. The Commission may impose an additional standard of the practice for the permit the amended permit issue for the storage facility safety standard of the practice for the amendment for the Commission for the storage facility that is an interstate with the gas pipeline facility compatible with the federal mineral standard. Commission shall require for the record safety of the device required with A1 or B filed with the Commission, maintained with the owner or operator, made available inspection by the Commission. Acts 1997 and 91. 256, the limitation of power of the municipality of the county. Municipality county may adopt the bring forth of the ordinance for the establishment of the safety chain of the principal practice applicable store facility subject to the regulation of the subchapter of another state law and federal law. Acts added in 1997. Art 91-257, safety procedure manual. The Commission may require for the owner operating the storage facility to prepare a safety procedure manual each storage facility to the file for the copy manual for the Commissioner to make the mail available to the inspection under the 91-240-54. 91-258, the reports and records and reports on owner operating the storage facility shall maintain the records and make reports relating to the construction operation maintenance of the facilities required for the Commission will provide either information required for the Commission related with the construction operation maintenance of the facility. B, the Commission may provide with the reports required within subsection A. 91-259, the damage to the storage facility, disabling safety device, person may not intentionally damage the storage facility, disable the safety device, storage facility exempt, repair, maintain, test, replay for the device, or other conduct other activities reasonably necessary for the safety operation of the storage facility. 91-260, the injunction civil penalty, the Attorney General will require that the Commission shall bring with civil action a person who is violated or violating this subchapter of the rule adopted order for the permit issued under the subchapter injunction for relief of the restraint of the person from the violation, assessment and recovery of the civil penalty of violation, both relief of the civil penalty of the selection, but not exceeding $25,000 each violation. Either J, with the continuing violation to be considered separate violation for the purpose of the penalty assessment, the maximum penalty assessed for the related series of the violation not exceeding $500,000. As added in 1997 to 91-261, administrative penalty, the Commission may suffer to provide his or his section under Section 91-262, 263, and 264, administrative penalty against a person who violates subchapter of the rule of the adaptive in order for the permanent issue in the subchapter. Subject providing subsection C of the penalty, each violation is an amount that not exceeding $10,000 of the maximum penalty is set for the subsection related to severity of the violation not exceeding $200,000. The penalty for each violation, Section 91-259, may be the amount that is not exceeding $25,000. Maximum penalty assessed under the subsection continuing violation may not exceed $300,000. Usually, the violation continuing to occur may be considered the near separate violation for the purpose of the penalty for the assessment, subsection B and C. E. The determination amount of the penalty commission shall be considered for the 1. The severity of the violation, could for the natural circumstance, for the extent of the gravity, prohibited to act for the hazard, potential hazard created for the health and safety, economic welfare of the public. 2. For the economic harm of the property environment causing the violation. 3. The history of the previous violation. 4. The amount necessary to deter the future violation. 5. The efforts to correct the violation. 6. Any other matter of the justice may require Acts 1997. Section 91-262, the administrative penalty assessment procedure for the administrative penalty be assessed only after the charge for the 91-261 have been given the opportunity of the public hearing. The public hearings held with the commission shall make the final with the issue of the written decision to the occurrence of the violation penalty of the only amount warranted violation incorporated within issue for the appropriate order requiring the penalty to pay if appropriate, the Commission shall consolidate with the hearing with other proceedings. If the person charged with it under Section 91-261 fails to make the advantage of the opportunity of the public hearing, the penalty may be decided for the Commission after the determinant that the violation occurred with the penalty of amount warranted with the violation. The Commission shall issue an order with the requirement of the penalty to be paid with the Commission. To give the notice of the Commission, order with the person charged with the violation provided with the Chapter 2001 Government Code. That the notice must include with the statement of the right of the person judicial review of the order. 91-263, payment of the administrative penalty not later than 30th day of the day of the commission of the order of the imposed administrative penalty becoming the final with the providing Section 2001-144. Government with the person charged with the violation pay the amount of penalty, filed with the position judicial review the contesting amount with the penalty, fact of the violation, both the amount of the penalty and the fact of the violation, without paying the amount of the penalty or filed with the position judicial review contesting the amount of the penalty, the fact of the violation, both the amount of the penalty and the fact of the violation. Within 30-day period, the person who acts under subsection A3 may stay with the enforcement of the policy, pay the amount of the penalty with the court placed in the escrow account, given it to the court supersedes with the bound and approved with the court with effect until the judicial review of the order decision is filed, the request for the order court to stay in enforcement of the penalty, filing with the court with a sworn affidavit to stay with the person financially unable to pay the amount of the penalty, financially unable to give it, to supersede with the bond, and deliver a copy of the affidavit with the commission. If the commission review the affidavit under the subsection B, but the commission may file with the contest of the affidavit with the court no later than the 5th day after the day of the copy of the receipt of the court shall have the hearing of the facts alleged with the affidavit is assumed as the practical the person who files an affidavit with the burden proving the person with the financial able to pay the amount of the penalty given the supersede with the bond. If the person does not pay the amount of the penalty is not stated, the commission may refer to the matter of the Attorney General for Enforcement Acts 1997. Section 91-264, Judicial Review of Administrative Penalty. Judicial Review of the Commission order imposed administrative penalty institute the filing petition is provided by the subchapter G of the 2001 Government Code under the substantial evidence rule. If the person paid for the amount of penalty with the amount that is reduced for the non-assessed for the court shall order for the appropriate amount plus the accrued interest to be remitted to the person the rate of the interest of the rate of the charge for the loans depository installation New York Federal Reserve Bank of the shall be paid with a period beginning on the day of the penalty paid and ending on the day of the penalty is remitted. If the person gave supersede with the bond, with the court shall order for the release of the bond without further action from the person if the penalty is not set for the court for the bond penalty with the payment of the penalty amount determined and penalty collected within this section should be deposited with the credit with the general revenue added to Acts 1997 amended in 2011 subchapter J. Payment for procedures of sale. This 91-401 definition subchapter pay the remains of the person legally entitled for the payment of proceed with the derived of the sale of the oil of the gas well located on the state. Payer of the main for the payer party with the undertaker for the distributor the oil of the gas received with the payer of the payee who has the purchase for the production of the oil of the gas generated with the such of the proceed with the operated well with the such production obtained with a leaser under a lease. On the royalty is due to the payer of the first private purchase for the such production of the oil and the gas and oil of the gas well within the left of the owner rights to produce the oil and for the gas leave of the pooling order and the first purchase has entered into the agreement providing with the proceed with the derived from the sale of oil gas to be paid with the first purchase of the owner with the right to produce thereby the deemed to pay with the habit of responsibility paying with the proceed with the receipt of the first purchase of the payee division order means the agreement is signed with the pay directing the distribution, proceed with the sale of the oil, of the gas heading, casing head, with the other related hydrocarbon, the oil, with the direct, with the authorized payer to make the payment for the product taken in accordance with the division order. When used here in the division order shall include the transformed oil transfer order. Transfer order means the agreement signed with the payment, the transfer, the new payee, the directing payer, or the division order for the pay of another person and a share of the oil and the gas produced in Acts 1983, amended in 91. Section 91.402, for the time of the payment, the proceed with the proceed with the proceed with the draft of the scale of the gas for the proceed production of the oil of the gas was located with the state of the paid to each payer of the payee or payer on or before 120 days after the end of the month, the first share of the production from the well, but at the time of the payment it must be made by each of the payer with the timely base for the according with the frequency of the payment is specified at least other written agreement between the payee and the payer. If the lease agreement does not specify by the time of the payment is subsequent, the proceeding must be no later than 60 days after the end of the calendar month of the subsequent oil production is sold. 90 days after the end of the calendar month of the subsequent gas production is sold. Payments of withdrawal without interest beyond the limits of the sale in subsection A. If there is any dispute concerning the title, the would affect the distribution of payments, be reasonable doubt that the payee has sold the authorized sale of the share of the oil of the gas purchase of the production has clear title of the interest of the proceed with the production requirements of the title option, the place of the issue of the titles, indemnity with the whereabouts of the payee that has been satisfied by the payee with a reasonable request for the curative the information has been made by the payer. The payments are subject to the title support for the lien under Chapter 157 of the Family Code order written withholding issued in Chapter 158 Family Code paid. It does not have the common law cause of the action breach contractor against the payer of the withholding payments over the subsection being left with the dispute concerning the title of the contract requiring the payment specify otherwise. C1, a condition of the payment to proceed with over the sale of the oil, of the gas, of the production, over the payee, they shall be entitled to receive the single division order payee containing only the following production provisions. A, the effective date of the division order, transfer order of other instrument. B, description of property of which the oil and gas has been produced, the type of the production fraction with the other decimal inch for the production claimed by the payee, with the type of the inch for the certification title to be shared with the production claim. Otherwise agree with the parties for the agreement if it is notified of the payee of at least 1 month in advance of the effective date with the chain of the interest of the production owned by the payee. The agreement identified with the payee with the reimbursement pay over the payer over the payments made over the payee that does not have the merchant bill title over the production sold. Authorization to suspended payment to pay with the production resolution of the title of dispute with the adverse claim and to serve with the regarding with the interest of the production claim by the payee. E, the name and the address of the taxpayer, identification number of the payee, with the provision of the valuation time and the settlement of the oil gas production of the payee. G, the notification of the payee, the other statutory revenue available to the payee with regard to the payment to moving to the Celestial Division order does not amend with any lease operating agreement between the interest owner of the leaser and or operating with the other contract for the purchase of oil gas. In alternate provision, subsection C, with this section satisfied with the division order for the all the payments substantially filed in the form of content, show the division 2 order property number, effective within date. Undersigned severally, not jointly certified with the legal owner of the interest set out below for the oil-related liquid hydrocarbon produced with the property described below, operator name, property name, county, state, legal description, order number, tax ID, social security number, paid, division, interest. This agreement does not amend any lease for the operating agreement between the interest owner of the leaser or operator of the annual of the contract for the purchase of the oil and gas. The following provisions apply to the interest the owner of the who executed the agreement to term the sale of the undersigned will be paid in accordance with the subdivision interest set out below, set out above. The payer of the shall pay with the party of the price agreed to a property with the oil to be sold with the presumed the division or the purchase. So compute with the quantity to make correction with the gravity with the temperature with the make with the deduction of the impurities. Payment from the effective of the date with the may be paid with the payer's check with the base for the division of the interest of the oil run during the parent preceding calendar month from the property listed above. The less taxes required by the to be deducted permitted for the payer over the purchase. Payments less than $100 may be accrued before the disbursement. The total amount that equals $100 or more until the 12 months for the accumulate whichever occurs first. However, the payer must be accumulated proceed with less than $10 until each of the production cover the payer's responsibility for making the payment of the production cover with whichever occurs first. The payee will agree with the refund. Payer amount to be distributed with the interest, but not interest to pay that he does not owe. Or to enemy, if the owner agree with the identify with the whole payer for the harmless liability result of the payment of the made for the owner according to the subdivision interest including but not limited to the attorney fee of the judgment for the connection with any suit with the effect for the owner's interest of the payer that is made with the party. The suit withholding funds. If the suit is filed with the effect for the interest of the owner written over the shall be given the payer with the other together with a copy of the compliant petition filed. In the event the claimant is dispute with effect for the title of the division interest created with the payer herein, payer is authorized to withhold payment of the accruing with such interest without interest, unless otherwise required by applicable statute until the claim or dispute is settled. Termination of the agreement is effective the first day of the month that begins after the 30th day of the date written with a notice of the written notice of the termination received by either party. Notice if the owner agreed to notify the payer of the writing with the change of the division and interest including change of the interest of the contingent pay with the money with the expiration time. No change of the interest buying with the payer until the record with a copy of the instrument with a change of the document satisfactory to evidence. Change of the furnished bill with the payer with the time of the change occurs. Any time with the interest that may be the effect for the first day of the month following the receipt of the notice of the payer and correspondence regarding with the agreement shall be furnished with the dresser listed unless the other wise advised to either party. Additional legal rights provided with the term provision of the subdivision and owner may have certain statutory rights and laws under the statute. Show signature of the Social Security witness or interest owner tax ID number and address. Failure to furnish the Social Security number, tax ID number will result of the withholding the tax according with the federal law. Any tax withheld with the federal refund for the payer. If the owner producing the property will not sign with this division with the covenant contained with this provision with addition to those provisions provided in this section, payers shall not withhold payment solely because such refusal of the owner of the producing the property refuses to not sign the division or with includes only with the provision specified in subsection C with the section payer with the may withhold with the payment interest until the size of the division is assigned. 5. The payment over the remit for the pay for the annually for the aggregated 12 months for the accumulation proceed with the pay with the own with the pay with the total amount of the 100 or less of the production from the oil, gas well with the pay with the must pay with the payee. However, the pay must accumulate proceed with the less than $10 until the production. See with the payer responsibility for the making the payment of the production. See with whenever that occurs. On the written request of the pay with the payers will remit the payment accumulated proceed with the pay annually with the payer over the payee less than $10. On the written request of the payee, the payer shall remit with the proceed payment of proceed with the payment monthly, and when the payer owes the payee more than $25, but less than $100. Or G, the division over the binding with the time of the extent of the have been acted for the made with the base for the settlement payment from the time of the notice of the given in settlement that will not be made with the provided within with the sheet of the binding division or the terminable, even the party 30 days written notice. 8. The execution of the division order between the royalty owner and leave between the royalty owner of the party other than the leaser should not exchange with the leave of the leaser specifically expressly implied with the obligation of the oil of the gas leave, including any of the obligation market production reasonable prudent leaser provisions of the division order of the payee over the less than the leaser and away for the contradiction of the provision of the oil and gas leave that is invalid extent with the jurisdiction of the division order that may be used and clarify the royalty settlement term with the oil and gas lease with respect to the oil and or gas sold in the field produced for the gathering point with immediately is the same with the terms market value with the market price with the prevailing price in the field with the other source for the language which is the base of the valuation of oil and gas leaks shall be provided amount relied with the mouth as well with the sale of the such production on arm's length transaction added Acts 1983 amended in 2017 and 2021. Section 91.403, payment of the interest late payments if the payment has not been paid with a reasonable time and specified in 91.402 for the code of the payer of the must pay with the interest at the beginning with the expiration of those time limited with 2% point of the percent of the rate charged on the loan depository institute with the New York Federal Reserve Bank with unless of a different rate with the interest specified written agreement between the payer and payee. Subsection of the section does not apply with the payments withheld or suspended the payer beyond the time limit specified in 91.402 with its code because of the condition enumerated in section 91.402 with its cover the payer's obligation paid with an interest payee right to receive the interest on the subsection A with the section terminate discover the spirit proceed with the accumulated interest for the comptroller provided Title 6 property code added to Acts of 1983 and amended in 1997. Lastly, 91.404 non-payment of the oil and gas proceed with the interest of the payee with the seek for the relief of the failure of the payee to pay timely proceed with the sale of the oil and gas interest of the oil of the gas required in section 91.402 and 403 of this code. The payee must give the payer written notice of the mail of the failure with the prerequisite beginning with the judicial action of the payer or the payee. The payer have 30 days after the receipt with the required with the notice of the payee with the proceed with the duty with the respond with the stating with the withdrawal writing with a reasonable cause of the non-payment of payment to cover the action for non-payment of the oil and gas proceed. The interest of those proceed is required in section 91.403 with the codes of current competent jurisdiction county with the oil gas well is located in 1983. Section 91.405 exemption for the subchapter that does not apply for the royalties payable to the board of the ridge ends for the university system and under the lease for the land with the dedicated for the permanent university fund with the general land office provided subchapter D with the chapter 52 of this code added Acts 1983. Section 91.406 for the 20 fee of the minimum award of the suit with the file with the collect with the pros for the injury for the time of the subject of the coast should include any foul judgment in favor of the plaintiff for the award of the reasonable alternative fee for the actual damage of the plaintiff of less than $200 additional amount with the total amount with the damage of the $200 Acts 1987. 91.407 the notice to change of the payer with the following change of the payer with the new payer has given the written notice to each of the payer with the payer from the distributing oil with the proceed with the notice for the given of the payer pays designer or the payer with the designer's most recent known address upon receipt of the payer's address of the operator leaser operator or leaser of the payer must provide with the notice for the time permitted with the payment to proceed with according with the condition of the payment to provide in section 91.402 but the notice must include information required in 91.502, 1, 2, and 12 of the 91.503. Payer's telephone number to notice must be given the rent included with the division order checks it up with the attachment of the payment form. Payer is obligated to pay interest for the pay with the owner, section 91.403, if it does not give the pay with the notice for the required the section liable to pay over the interest under the section rate with the 2% with the more than the rate for the providing subsection. Alright, 91.408. Information paid for the proceed with the production of the certain well of the pays over the proceed with the sale of the gas production the type formation defined in section 29C2B with the Internal Revenue Code 1986. Annually should be the pay with the statement that provide with the information necessary for the compute of the federal income tax provided with the section from the gas which payment was preceding the year included. Information described in section 91.502.1 over this code of the volume of the gas measured for the 1,000 cubic feet heating value, million for the British thermal units over the 1,000 cubic feet, payer of the furnished statement the requirement of the subsection no later than March 15th of each year. Subchapter K, saltwater disposal pits. Alright, section 91.451, definition subchapter saltwater disposal means for the collecting pit of the surface of the ground with the use of the soil to evaporate, oil field brines, geothermal reach of the water on the mineralized water. Prohibited activity except for the providing subchapter for the person conducting oil for the gas development, production, operation, geothermal operation, underground hydrocarbons over the operation may not use the saltwater disposal pit, restores evaporation of oil field brines. 91.453, commission authorized on written application for the commission of the design to the employee made administratively authorized to provide saltwater disposal activity on temporary emergency basis with the unwritten application for the commission on its designated employee with administratively authorized person using imperative surface of the pit with the conjunction with the geothermal operation, underground hydrocarbon storage operation approved with the saltwater disposal operation. In the case where the consecutively use of the saltwater disposal gate with the cover of no pollution surrounded with the product of the agricultural land with no pollution with the ground surface of the water supply with the cover of the absence of the such water with the due with the physical location of the such waters by naturally occurring the impervious barrier with the commission of the design to employ with the maybe the administrator of the authorized person over the saltwater disposal pit. Authorization agent under section must be written in with the most be stated with the condition of which the pit was must be operated. Acts 1983. Section 91.45 for removal of the authorized pit. For the person with the authorized to operate with the saltwater disposal pit under section 91.453. This code shall close the pit within 45 days of the being ordered for the close of the pit, but the commission with the provide for the commission may grant with the extension of the reasonable for the period of the time shown with a good call for the upon request for the extension of the surface owner of the owners of the land upon the pit is situated with the saltwater disposal must be closed with the compliance with the subchapter of rules and standards specifically adopted by the commission closing saltwater disposal pit with the person authorized to operate with the pit shall remove all the saltwater waste and then shall be backfill the complete with the compliance with the commission improve the procedures. Section 91.455 the rules and standards specification commission shall adopt the rule to define the procedure of obtaining the authorization to operate saltwater disposal pit, to define the conditions under which the authorization of saltwater disposal pit was granted, 3 establish standard for the saltwater disposal pit authorized by the condition, 4 provide standard for the process and proper cleansing of the saltwater disposal pit authorized by the condition, 5 provide other standard provision, standard procedure requirements necessary for the carry out of the subchapter B. The commission by the rules shall require linear specification, installation procedure for the adequate insulate the saltwater disposal pit, the drainage cleaning and the closing of the saltwater disposal pit. Alright, 91-456, injunctive relief of the person operating with the saltwater disposal violation, subchapter of the commission rule for the term of the specification of the commission may have the attorney general of the institute with the district court of the county owning the saltwater disposal pit located with the injunctive relief restraint of the person continuing with the operating with the pit violation, subchapter of the rule, standards, or specifications of the commission. 91-457, the removal of the unauthorized pit. The commission may order for the operating of the saltwater disposal of the pit with the violation, subject to the close of the pit, in compliance with the subject of the commission rules and stating the specification pit owner's expense. B, if the person ordered the close of the saltwater disposal of the pit under subsection A refuse the close of the pit in compliance with the commission orders and rules, the commission may close the pit, use the money from the oil of the gas regulating cleanup fund, but they may direct the attorney general to file suit with any of the court's competent jurisdiction of the county to recover the applicable penalty and the costs incurred by the commission closing the saltwater disposal pit. Acts in 1983, amended in 2011. Section 91-458, criminal penalty. A person who violates Section 91-450 code under the commission under subsection A, Section 91-457, and commits the offense offense under the section Class A misdemeanor. 91-459, civil penalty. A person violates subchapter of the rules, standards, specification of the commission, failed to comply. Close saltwater disposal with compliance with the chapter of the rules, standards, specification of the commission, order of the commission, authorization, pit, subject to civil penalty not less than $100 to more than $10,000 each with the violation failure to comply. Attorney General shall cover them with the civil penalty providing subsection A of the section court with a competent jurisdiction. Any cost recovered the attorney shall under the subchapter shall be deprived of the oil and gas regulation cleanup fund repealed by the Acts 1991. Added Acts 1983, amended Acts 2011, subchapter L, royalty reporting standards, and we got the tape there.